In any private company with more than one shareholder, the way in which the shareholders interact with each other will have a critical impact on the long-term success of the business. At best, poor shareholder relations can be a significant distraction from the day-to-day running of the business. At worst, shareholder disputes can destroy company value and cause an otherwise viable business to fail. Here with me to discuss the role the shareholder agreements can play in avoiding these pitfalls is Michael Moore, a corporate partner with KPMG Law. So Michael, what is a shareholders agreement?
Thanks, Audrey. A shareholders agreement is a private contract between shareholders in a company, and typically it sets out the basis on which the company will be operated and managed, and it'll also set out the basis on which the relationship between the different shareholders will be governed. And typically it covers key terms like how the board of the company will be composed, the basis on which key decisions will be made, and whether or not certain shareholders have a veto over those key decisions, and also if and when you can transfer shares in the business and if any restrictions apply to those transfers.
So it's a really important document covering very important issues. Why do you think it's so important to have these matters agreed by the shareholders?
A shareholders agreement is like a corporate marriage, so it's important for the shareholders at the outset to ensure that their expectations are aligned with the other shareholders. But unfortunately, with any marriage situation, relations between the parties and the shareholders can break down. And in that situation, that's where a shareholders agreement shows its real worth. Because a shareholders agreement, if it's well drafted, will provide for dispute resolution mechanisms. It will provide that if there is deadlock, that issues can be referred for mediation, or they can be referred to an expert for independent determination. And also they typically provide that in circumstances where the parties just can no longer continue to work together and relationships have irretrievably broken down, that one or other of the parties will sell their shares and exit the business, or that you sell the whole business as a going concern. So when you put a shareholders agreement in place, the hope and expectation is it'll be drafted, it'll be put away in a drawer and never looked at again. But in circumstances where there is a dispute, where there is disagreement, it ensures that that can be handled in a reasonable and sensible way, away from the glare of court publicity, and ensures that reputations and value in the business isn't damaged.
So in essence, really, a good shareholders agreement acts as a form of insurance policy against future potential disputes that may arise in the business. So when do you think shareholders should consider putting a shareholders agreement in place?
I think in any situation where you have more than one shareholder in a company, or in a situation where you have new shareholders joining a business, I suppose a shareholders agreement is particularly valuable in certain situations. So if you have a situation where a family business is passing shares to the next generation, or if you have a situation where you have multiple generations owning shares in the business, or in a scenario where you have certain shareholders who are directly involved in the running of the business and other shareholders who just aren't. So in a family business, you can include things that reflect the values of a particular family in a shareholders agreement. For instance, it's quite common to provide that shares in the company can only be transferred to other members of the family pool. The other situation where a shareholders agreement is very valuable is if management are taking shares in the business. That's a very good opportunity to set out a clear purpose for the business to ensure that everyone is aligned to drive value and growth in the business into the future.
Okay. Very good. Thanks, Michael. Lots of food for thought there. Many of those scenarios also give rise to critical tax considerations, such as the most tax efficient way in which equity can be passed to the next generation, and what retirement or other reliefs may be available. Such a review of reliefs is particularly important now, given the changes to retirement relief introduced by the recent finance bill. Also, adding management to the shareholder group also raises nuanced tax issues around their now dual roles as shareholders and employees of the business. If you're interested in how KPMG and KPMG Law can help put a shareholders agreement in place for your business, or indeed assist you with any of your corporate legal or tax needs, please do get in touch.